Our primary concern here is the idea that defendants will be able to abscond from supervision, wait out the expiration date of their term, and if a warrant or summons does not issue under 3583I, they will be able to render the supervision component of their judgment a nullity. That is the worst outcome here. That does not serve the system that Congress enacted in the sentencing
But isn't that
reform.
exactly what Congress wanted? I mean, the reason why we have I think, is because Congress suggests that it's only in the situation in which a warrant does issue under those circumstances that the court's authority can extend to allow for a revocation. So I think what you're asking for seems diametrically opposed to the policy choice that Congress has made about the circumstances under which the person can be held accountable for something.
So just as, oh, I'm sorry.
Yeah.
I think I part ways with you on the history and purpose of subsection I. So I would point out, petitioner puts a lot of marbles in the 3583I bucket because that is essentially the only way that she's able to get around this idea that somebody
because that's what Congress says about when this can be extended, when the power can be extended to hold her accountable.
Well, I would point out, just as a matter of history, that subsection I was not enacted until a decade after the Sentencing Reform Act. So in order to buy into her view, you have to accept the idea that the Congress that enacted the Sentencing Reform Act wanted supervisees to be able to entirely defeat the supervision component of their judgment through fugitivity and waiting out the expiration date of the sentence. I don't think that that's plausible inference.
But what they did was they put the burden on the government or the probation office to alert the court and get a warrant during the time when the person absconds.
But Justice Jackson, there was no 3583I at that time. There was no 3583I. There was no warrant or summons extension mechanism for the first 10 years that the Sentencing Reform Act was in effect. That was not enacted until 1994.
And your conclusion is then that we have to, now that 3583I exists, interpret it consistent with the pre-existing state of affairs.
Well, I have additional reasons that I think 3583I is insufficient, but I do think it's important to look at the history and think about what the Congress that enacted the Sentencing Reform Act was trying to do. And I think, if Congress gave district courts for the first 10 years of the supervised release system, gave district courts no tools whatsoever to go after absconding supervisees who were able to wait out the expiration date of their term, I think that is very strong evidence that Congress anticipated that traditional ideas of fugitive tolling would be incorporated into the new supervised release system that they were enacting. But in terms of, what I think 3583I was going after, I mean, as I think petitioner acknowledged on page 6 of her opening brief, and as the Second Circuit recognized in the Janvier case, this was really about a very narrow subset of late-breaking violations where there was not time left on the clock for the district court to conduct the revocation hearing required by Rule 32.1. Every court to have passed on 3583I has talked about this as being a provision that is designed just for those very late end-of-term violations. It is not a general fugitive tolling provision.
I guess,